May I seek
Next week.
one writ appeal disposed of by this honorable court on 27th November 2024, sitting along with Justice Adiga. Now there has been some mistake in the order which
Just a moment. Yes.
there is some mistake in the order which the deputy commissioner thinks that it is coming in the way. Therefore, I am requesting.
It will be listed as
It's a disposed of matter. Therefore, I am mentioning.
Your Ladyship, this matter has been remitted by the Supreme Court. It was listed. However, all the petitioners are no more. So they appeared and took an adjournment, the counsel on their behalf. We are on behalf of the legal representatives. We have filed the impleading applications to bring the legal representatives on record. And there are 3 connected matters. And there is a request to dispose it off within 4 months. And the order was passed in January.
Lord, this.
When
can be listed.
My lord, this matter pertains, my apologies to mention this matter is resolved by my lord. Lord's little answer.
Tomorrow. Give a date. Give a date. Yes. All alienation will be subject to result of the appeal. Yes.
Any mentioning?
Wait. File a.
My lords,
Very good.
my lords, the matter is reserved, my lords. I am passing on the citation. The matter was reserved on 4-3, my lords.
What citation?
The appellant has referred to one judgment. It seems to be overruled by this judgment, my lord. Just passing on the citation.
Whether it is listed for judgment has probably been dictated also. Yes. Court hall 2 matters. Please.
I'll call out.
Yes. No. He wants listing of matters.
Tomorrow they can.
Yes.
Serial number 28.
Just a moment. Just a moment. Just a moment. Okay.
Any mentioning? List 1, page 1, seal number 1 and 2. Page 2. Court hall 3 though. Page 2, seal number 3 to 5. Page 3, 6 to 10. Page 4, seal number 11. Page 5, 12 to 14. Page 6, seal number 15. Page 7, seal number 16. Page 10, seal number 17. Page 11, seal number 18. Page 12, seal number 19. Page 13, seal number 20 and 21. Page 15, seal number 22 and 23. Page 16, 24 to 29.
Serial number 28. 10 days. 10 days.
26. Just a moment. 26. We'll list it immediately after the holidays. Yes, at the
Serial
request of
number
the
28.
counsel for the appeal. 28, yes.
20. So 10 days time may be. It may be done because this matter.
Who appears against you? Have you informed? Please inform the other side and inform the court officer. Date will be given. Yes.
Page 17, 30 to 32. Page 18, 33 and 34.
Serial number 34.1, my lord. For authorized each time.
He can't give time in only one matter, counsel. Have you informed the other side? Have you informed? Who appears on the other side?
My lord, serial number 34-2, I have filed my NOC Wakalat and my name is not been shown in the list here on. My lord, kindly list the matter after.
Just after holidays.
Oh.
At the request of the Government Council. Just after holidays. Yes.
Page 19, 35 and 36.
35, my lord, I appear for the appellant. Other side contesting respondent has been informed. This matter depends on the notification challenge before the learned single judge. It may be, it is listed on 17th, my lord.
Yes. Temporary permit. And the, oh, it's there already. Nothing in it, but then, yes.
Immediately after.
Request.
Page 20, seal number 37. Matter pertaining to Court Hall number 2, page 1, seal number 1 to 4. Page 2, 5 to 7.
Serial number 3, serial number 7. Serial number 3, my lord.
Just a moment, please. Call it page by page.
List to
Please call page by page.
page 1, seal number 1 to 4, seal number 1.
Serial number 3, my lord. Maybe given a week's time to.
Week's time granted at the request.
Page 2, 5 to 7.
My lord, for serial number 7.
Settlement 5, my lord.
Hmm, 5.
Kindly pass over. Five.
Pass over.
We settled it since application.
Settlement.
Settled.
Yeah,
Okay,
we'll
pass
find
over.
out.
My lord, serial number 7.
Yes.
My lord, requires time. We have to file a written arguments.
You seek time.
Yes, my lord.
At request, 2 weeks, huh? After 1 week or 2 weeks?
2 weeks
2
of
weeks,
time.
yes.
Serial number, reference regarding the question on this matter is pending before the Supreme Court. So the matter may be heard after the pronouncement of the judgment in Supreme Court.
What is the question?
Notification of arbitral award under section 34 and 37.
Hmm. Whether it can be modified.
No, the question is pending before the Supreme Court.
Whether the arbitral award can be modified. Hmm.
Meet there in your village after 2 weeks.
Holidays.
Yes, at request.
Page 3, 8 to 10.
Serial number 8, I am appearing for the respondent number 4.
At joint request. Yes, 2 weeks. Interim order, if any, stands extended.
Page 4, 12 to 14.
Serial number 12, lord. Needful has been done.
Serial
Number 12.
12.
Needful has been done.
Has
Yes.
been done.
Council submit that needful has been done. Office to verify and verify. Office to verify.
Page 5, 15 to 18.
Serial number 15, I appear for the first time. My application for.
Early hearing.
May I request for the 21st?
No, no.
request for the 21st.
Date cannot. be.
Date cannot.
Date we can't give. Yes.
At request, re-notify next week.
Next week.
Yes.
Page 6, 19 to 21. Page 7, 22 to 26.
22, my lord. 22, my lord. I put appellant upper vacation.
Yes.
25.
At the request of counsel for the appellant, re-notify the first week of, yes.
My lord, to serial number 25, my lords. Kindly have this matter on 17th, my lord. 2 days time
Who
may
is
be
it?
granted. I am for the
Who is
petitioner,
it?
my lord.
We can't see anybody.
I'm
Yes.
I'm for the petitioner, my lord.
Well, legend.
I have no contact with the respondent, my lord. I have no contact.
Yes, we will adjourn the matter for 2 weeks at request of the counsel. petition.
1 week, 1 week, my lord. 1 week, one document has to be secured, my lord. Only 1 week.
No, at request of 2 weeks.
Yes.
Much.
Page 8, 27 to 32.
Serial number 27, my lord. I am appearing for respondent. Kindly have it on any next week, ma'am, for admission.
Have you informed the appellant
No, I am the respondent, your honor.
or the respondent?
There is an urgent.
Request, the request of respondent, re-notify after 2 weeks. Yes.
Much.
Page 9, 33 to 38.
30.
Serial number 37.
34, my lord.
30, 31, please give dates.
30, 31. Yes. At
34,
request
my
of learned counsel for the petitioner.
34, my lord. And after vacation, you only call, my lord.
Serial number
So for the
30.
appellant.
I'm for that.
Aye. For the request of the counsel for the appellant.
Serial number
Notify
37.
First week.
It is a part kindly post the next week.
37.
37.
Next,
Next week. At request.
23rd. 14%.
At the request of party in person ಅಂತ ಹಾಕೊಳ್ಳಿ. R2 ಅಂತ. At the request of party in person. R2.
Page 10, 39 to 41.
Serial number 41, Your Lordship. I'm for the appellant. I pray for 2 weeks. Your Lordship.
Have you informed the other side that you're seeking a long adjournment? Yes, re-notify.
My lord, serial number 40.
Thank you, Lord. The finish answer.
My lord, serial number
Page 11, 42 to 46.
42, Your Lordship.
My lord, serial number
1 week's
40,
adjournment. Your Lordship. 42, 1 week's adjournment. I'm for respondent. The appellant has been informed.
My lord, serial number 40, my lord.
Joint
1 week adjournment.
Counsel, please wait.
1 week's adjournment.
Can't you see that court is going on? Please wait.
42 is joint request. 2 weeks.
Your Lordship, 1 week, Your Lordship.
No, madam. We don't know how the board works.
2 weeks. Yes.
My lord, serial number 40.
Page 12, serial number 47 and 48.
My lord, I am for serial number 47. I am the respondent. This is a service matter where after retiring in May 22, I was dismissed in June 22, depriving all my benefits. Honorable single judge gave the judgment in my favor. They have come on
Re-notify.
appeal. After that, they are not doing anything.
Yes.
I want a short date, Your Honor,
Yes,
please.
after 2 weeks.
No, preferably in this month, and because he's a handicapped person,
And
wife
2
is
weeks.
a cancer patient. He's struggling without the
I
money.
did request last week.
28 4.
Serial number 40.
Serial number 40, the appellant counsel is mentioned.
Yes. What do you want in serial number 40?
My lord, 1 week adjournment.
Please, counsel, you're not audible.
My lord, 1 week adjournment may be granted.
Serial number, madam.
40.
40. 40.
Just after a week at the request of the learned counsel for the appellant. Final hearing matter, 230 matter can also be listed on some day. Give a date. Yes.
Lord's kind leave, my lord. With my lord's kind leave, my lord. Serial number 29, my lord. Final hearing, my lord. Kindly week's
Yes.
time, my lord.
Which list? How the list?
First list, my lord. I am for the respondent, my lord.
Railway claims and that.
Please, my lord.
Yes. Have you informed the other side? Appellant?
Please, my lord.
Yes.
Yes, my lord. Yes, my lord.
You are already informed?
I have informed. I have already informed, my lord.
Yes, yes. Hi. At request of learned counsel for the respondent, they notify after 2 weeks.
Please, my lord.
List 2, serial number 1, Bharat Kumar V, habeas corpus.
For the petitioner.
If the Lordship have this tomorrow, as a victim in this case would have something to say. Is what we learned.
Just a moment, just a moment.
Yes.
Tomorrow.
My case is that the victim has been placed under the custody of the CWC in the state home. My lords, away from the parent, which is as against, my lords, the POCSO Act as well as, my lords, the Juvenile Justice.
It may not be. It will depend on the facts of the case.
Yes.
Tomorrow.
That being the case, my lord.
Tomorrow, please. Yes. Please get instructions in the matter, and what the alleged detinue says will be of prime importance here. Anyway, what if there is an order by the CWC, then that order will have to be challenged as well. If there is such an order.
The order
Yes,
would be
anyway.
challengeable before this honorable court in the present petition. That would be
Tomorrow. Where is the order?
Please, my lord.
Where is the order? Where is the order?
Let's, the order is not produced.
Absolutely. So let us see
My
whether there is
submission is that the order itself is not there.
whether there is an order or not. Let him get instructions in the matter.
We suspect the role of the petitioner also.
Tomorrow.
The victim from
Yes.
List 3, so number 1, party in person, Mr. Mahesh Harvi.
Madam,
This is
Your
already
Lordship.
been listed. First time. This is coming up for the first time.
yes, Your Lordship.
This appears to be a
Child custody matter.
child custody matter.
Yeah, where in the
How
Tumkur
was
Family
the-
Court, for 5.5 years, the trial went on and the final judgment is pronounced. I was supposed to have the custody of the child for about 40 days during the summer vacation, but my respondent is not handing over the child. And at page number 124 of my compilation of the
Seeking to
judgment,
execute the order.
and
Why
120,
don't you get the order from the family court which passes the order?
they went before the family court and they stayed it for 7 days, from 29th March to 4th of April. And after that, there is no stay. And even despite orally family court giving orders, they are not complying.
How is a habeas corpus writ petition maintainable in these
Yes,
facts?
madam, I have judgments where it is maintainable. This honorable court has held it
Yes,
in the
we'll
previous
hear
cases.
you on the maintainability. Tomorrow.
Notice will have to go to the third respondent.
Yeah.
Why notice? Let us see.
Yes,
whether
yes,
maintainable or not.
maintainability.
Maintainable or not?
I'm ready with
Tomorrow,
the,
tomorrow.
No illegal detention.
List 1, pertaining to quota number 3, seal number 1, admission, Sumana Naganan.
Lord, appeal had been admitted, my lord, but decided to be heard at this stage.
Can we hear it today? Can we give a date for the hearing?
Order the improved order.
My brother tells me that it may not be wise to take it up today because there is a likelihood of a further disruption. So can we list this on some day in the next week and see whether it is possible?
Madam,
Because if we hear it partly today, then on another date, we'll have to
any time.
23rd or 24th?
24th.
24th.
24.
Is that all right?
24th is okay. Great.
Seal number 2, Shivram Bhatt.
In this case, my lord, your lordship has heard the matter for some time. This is with regard to the retirement benefit, my lord. The petitioner was suspended from the from his service from 12/8/2003. Now, my lord, from the day thereafter.
Pass over and we can hear.
We can pass over and hear this. Are you ready?
Yes.
Pass over.
Preliminary hearing, seal number 3, Yampayan.
Here for the appellant.
Just see what the matter is and then.
Contract basis in Tamani to Vijaypura.
Coming.
Yeah. Oh,
Yes. Synopsis. So it appears to be some problem today. Delay in opening.
hmm.
Name.
Junior engineer on daily wages. Municipality.
A simple matter. The issue is
So this also we can pass over in here.
We can hear this also.
annexure P.
Everybody is ready?
Yes, please.
Pass over. Delay can be condoned, we can decide on merits.
Hearing on IA, so number 4.
Lord, IA number 7, 8 and 9 have been made to bring the LRs of appellant number 2. There is a delay of 884 days. An application has been filed.
What is the reason for the delay? To bring the LRs of the appellant on record. Only out of curiosity, we'd like to know what the reason you have stated for the delay is.
When you have appellant.
With the COVID.
On death of appellant, these 3 IAs, order on IA and 7, 8 and 9. The death of the appellant, these 3 IAs have been filed to for setting aside abatement, for bringing LRs of the disease and the condonation of delay in filing LR application, full stop. We have perused the affidavit accompanied to the IAs, accepting the cost shown in the affidavit, the delay of 884 days in filing. The LR application is condoned according to IA 7 of 22 is allowed. Consequently, IA 8 of 22, the abatement set aside, and the appellant is permitted to bring the LRs of R2, proposed R2 to R4.
Yes, madam.
As the LRs of appellant.
No reason.
The
They'll have to amend the
IA number 1 of 2021, my lord.
Not
So for
even a
us,
sentence.
that IA is concerned.
Your Lordship, insofar as that application is concerned, I have
Amend the
objection,
cost
and
title
this honorable
according-
court, Your
amend
Lordship,
the cost.
already passed an order.
Ah.
Insofar as IA number 1/21 is concerned, Your Lord, what happened is that when the matter was pending before this honorable court, Your Lordship, they sold the property in favor of third parties. That third party has filed an application to implead, that for which I have filed an objection. And Your Lordship, this honorable court, after hearing the IA, said that this application can be heard at the time of mine matter.
IA 1 shall be heard at the time of hearing.
Yes, my lord. They'll have to
Non-amendment, what is the
Amendment
non-amendment of cost title?
Yes.
Yes.
My lord, one more thing is there. That is non-amendment of the cost title of deceased appellant number 1 and 5. 10 days time may be granted.
10 days time to
Publish.
to amend the cost title.
Grateful, madam.
Yes.
So number 5, Rukojira.
Appear for the appellant. There's a delay of 60 days. Partition suit,
Partition
my lord.
suit by the bank.
My lords, no, my lords. It was a mortgage property. A partition suit was filed against the bank and it was decreed, my lords.
Yes, accepting the cost shown in the affidavit accompanied to IA number 1 of 2015. The delay of 60 days in filing this appeal is a condoned. Accordingly, IA 1 of 15 is allowed. IA 1 of 2016 shall be called along with the main appeal at the time of hearing.
Yes.
We can be admitted.
None of the respondents have appeared, my lords, in spite of due service. Your lordships may fix a date for hearing.
We can be admitted and we can.
Yes, heard, admit. registry is directed to registry is directed to secure the trial court records. Yes. Yeah, list this appeal for
Much of.
hearing in the usual course.
Dismiss for non-prosecution. I file a NOC wakalat in this matter. The earlier advocate has passed away. So that's the reason, Your Lordship, they are not complying the officer objection. So after filing the wakalat, Your Lordship, I file a recalling application. So that's the reason, Your Lordship.
Cost, how much cost?
Allah is not mistake from my end. The council earlier the passed away. So that's the reason, Your Lordship.
Yes. Pay some cost.
That's what was intimated to him on the previous occasion.
The connected matter already is posted for arguments. 2 connected matters already posted for arguments.
The reason why that should be paid.
That's the reason. This court wide order dated 11/9/2017 dismissed the appeal for non-complying the office objections. Full stop. Subsequently, hence as such, IA 1 of 2000, IA 2 of 2018 filed to recall the order dated 11/9/2017. There is a delay of 142 days in filing the recalling application. Although we are not satisfied with the reason reason assigned in the affidavits, nevertheless, in the interest of justice, the IA 1 and 2 are allowed, subject to appellate paying a cost of rupees. Yes, to
500 euros.
2,000. 500. 2,000.
Obliged.
Not to
Paid
to Advocates Welfare Fund.
Advocate Welfare Fund.
Please.
Yes, within 2 weeks.
Kindly connect the matter.
This may be called along with RFA 313 of 2015, 492 of 2015,
And
492 of 2015, 313 of 2015.
And 298.
And 298.
Yes.
Kindly.
But they are all common judgment arising out of these
Accordingly,
cases.
appeal restored to original file and upload last year.
Kindly.
7.
But I
Mercy
filed an
Reddy
IM
ji.
for my lord earlier in my lord 2004 gift deed my lord filed a suit for partition 2010 my lord 78 purchased mother gifted the younger son and one daughter my lord. The elder son filed a suit for partition. Since he is running an optical shop belong to the father my lord, that was not given to him my lord. Suit for partition was dismissed, against which I filed this appeal. Any date may be fixed after vacation.
2016.
You file a
Paper book is filed.
paper book filed, yes. Copy also furnished to you.
So the-
Short question.
The office objections are compliant.
The land counsel for the appellate.
I'm for the, I
You are for
filed.
the
the-
respondent. You
I-
filed the IM.
I filed the IM.
Yes, yes. Since the appeal is of the year 2016, the IA 1 of 2021 is allowed. They list this appeal for hearing in the second week of
11/6.
second week of June, second week of June. So next, the land counsel for the appellant furnished the paper, served the copy of the paper book to the land counsel for the respondent. Yes, he acknowledged the same.
Seal number 8.
I am for the.
Narayan Rao,
Thank my
Mr.
lord.
Raj-
My lord, see,
Here this
some
matter.
inconvenience, my lord, start academician.
Along with the modification, they also can comes filing the above appeal and statement of objection.
Maintainability of appeal. Earlier, they filed appeal with their, it was withdrawn, and then they filed review petition. Review petition was also dismissed. Against the original order itself, they have come, they have not challenged the review order. Last time also we made submissions.
Senior friend is passed away today morning, my lord. Senior friend is one is passed away tomorrow morning, my lord. So that is inconvenience today.
If it is inconvenience to advocate,
Submitted that there is a bereavement in the family of the land counsel for the appellant, hence re-notify after 2 weeks.
Nine. Sunita.
My lord, I am appearing through this.
1 to 6, Your Lord. Lord,
My
I
lord.
have made an application for withdrawal of the deposited amount, Your Lordship. We are the landlords for the court below, Your Lordship.
Just a moment, Prashant wants to say something.
My lord,
The
this is
covered
the
matter.
case, my lord, if my lordship remembers, my lord, this is the case where they have filed 18-1 application, which has attained finality. Later on, my lord, they have filed 28 IA application and they have received the award, my lord. 18-1 application was finalized, my lord, telling that they have filed the application at a belated stage. I have filed my objection, detailed objection, my lord, for release of the amendments.
We'll hear the matter.
Pass over.
My lord, may pass over, please.
Pass over.
Please, your lordship, pass over.
My lord, kindly have it some other day, my lord. Some other day. my lord.
Lord, this application is pending consideration for the past 1 year, your lordship.
Next week, we will hear the matter. Appeal
Oh,
is
please,
next
my lord. Please, my lord.
at the request of learned counsel for the appellant. Yes.
At least day after tomorrow, your lordship.
28-4,
28.
Please, my lord.
Yes.
10, GM Anand.
Appellant.
Reporting settlement.
That I have already deposited before the executing court. I have produced the order sheet.
That's matter is settled, my lords. The only thing we are waiting is for the disposal of the funds. The lordships would call it after 4 weeks, my lords. We will report settlement. That is all.
Because the government has to release the amount. We have already paid 1 crore 80 lakhs before the executing court. Rest of the amount has to be released by the government. Till then, we have to wait.
Yes, it is submitted that parties have settled their dispute to report the same.
Please. Till then, Malala.
Yes.
Till then, till then, Malala, let them not precipitate because the execution is pending before the trial court. Execution 27.
Yes, not to precipitate the execution.
Please.
Let's, we will not precipitate since the matter is already settled.
Yes.
Very well, my lord.
He orally undertakes, that's sufficient.
Please.
B group, seat number 11, Ajay Kumar Patil.
That could be.
It is submitted by the learned counsel appearing for the petitioners in these matters that there were interim orders passed at the stage of admission of these writ petitions, and that the petitioners have participated in the admission procedure on the basis of the interim orders so passed. It is further submitted that the issue in question is covered by the judgment of the apex court in that is a
I've submitted the copies of the judgment.
in view, copy is not required. In view of the above submissions, these writ petitions are disposed of, noticing the interim order and making the same absolute. The admissions, if any, granted to the petitioners on the basis of the interim orders shall not be disturbed.
So in fact, serial number 18 also is the same.
18.
Also.
There also you.
Same issue.
Same issue.
All the matters
All
are
the
similar.
same.
Can be disposed of on the basis of this very
The same.
Anushka. Yes.
Yes, that could be disposed.
18 also. 18 also same separate judgment, but same.
18.
Oh, 11 matters are there, but 18 one judgment and is 11 separate judgment. Yes.
Grateful.
Orders, number 12, from Sid Malappa.
Only paper book ಮಾತ್ರ ಇರೋದಾ?
Memo for retirement. Memo for retirement is accepted.
I find the memo for retirement for appellant number 1A to E, please start. Only remaining appealing for appellant number 2.
Have you served the, what is the objection? Paper book? Paper book ಅಲ್ಲಿ objection?
Other side copy.
ಆಯ್ತು. Time ತಗೋ. 1 week ಸಾಕಾ? At the request. A week's time granted at request. They learn counsel for the appellant to comply the office objection. Memo for retirement ಯಾರು ಹಾಕಿದ್ದು?
He himself he is appearing only for R2.
R2.
One, our
Yes,
one's
learn
legal
counsel for
representatives
the
is not.
appellant submit, learn counsel for the appellant Sri Siddhamallappa files a memo for retirement stating that the legal representatives appellant number 1A to E has taken with the entire file and no objection wakalat from him and from him full stop. The placing the memo on record, comma, issue court notice, ಬೇಡವಾ? ಮತ್ತೆ ಅವರಿಗೆ ಏನ್ ಮಾಡುದು? Yes, yes. Memo is placed on record. Denotify after 2 weeks.
Nandak Kishore?
Non-finding synopsis.
I'm filing the written synopsis and the list of authorities complying with the order.
Already filed?
I'll file it now, Manoj.
ಇಲ್ಲೆಲ್ಲಿ ಇವರಿಗೆ ಕೊಡ್ತೀರಾ?
Please, Manoj, I'll file it by the course of today.
A week's time granted to do the needful. Yes. ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ.
14, Monesh Kumar KB.
Lord, I appear for the appellant in the connected matter. Lord, for the last two, Lord, 4 hearing dates, Lord, the very same objection, Lord, request to be complied, Lord, by the appellant in the connected appeal. Office has raised an objection, Lord, that court fee paid is insufficient. Lord, a submission was made before this court on the last date of hearing saying that sufficient court fee has been paid. This honorable court, Lord, directed the appellant to verify from the office and do the needful. Lord, it's urgency for me, Lord, because I am the land loser. I have sought for enhancement.
ಕೊಡಿ ಏನಿದೆ ಅದರಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ ಅಂತ. Learn counsel for the appellant in MAP submit that office objection has already been complied. To get this, learn counsel is directed to verify the same in the registry.
I am responding.
Last date he has submitted that office objection already been complied.
Lord, in the connected appeal, Lord. I am for the appellant in the second appeal. Connected appeal.
MFA 2726 only. The learn counsel for the appellant in MFA 2726.
Lord, I am appear for the appellant in 2681.
2681, you are for the appellant.
I am for the
You are
appellant.
seeking enhancement.
Yes, madam.
Lord, I am seeking for enhancement, Lord, and the beneficiary, Lord, wants the compensation to be reduced.
For enhancement.
There is no representation.
2726, he says that it is already complied with.
2681, Lord, I am for the appellant, Lord.
2726. He is appearing for the
Monesh Kumar. First appeal. 2726. This Monesh Kumar is not appearing. Where is Monesh Kumar? ಬರ್ತಾರಲ್ಲ ಅವರು?
ಬರ್ತಾರೆ.
ಹೇಗೆ ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ? ವಿಲ್ ಪಾಸ್ ಓವರ್. ಕಾಲ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಕರಿ. Last time we have submitted that it's already complied on.
Second matter, I am for the respond, I am ready.
ಆಯ್ತು ಬರ್ಲಿ.
15, Sachin BS.
Service notice to an RO. Yes.
That's 15.3. The matter was heard and they were directed to file a report on 30th January. They're yet to file any report to show that our land was utilized for the formation of BTM 6 stage. That matter may be dealing, my lords, because the rest are still for steps. Our matter was already heard.
Which is your matter?
15.2, my lords.
752.
715.
752.
15, my lords.
15.1.
715 is 15.1.
15.1.
15.1. No, my lord. 715, please.
715 is 15.1.
Please, 715.
He knows that.
Hmm.
Where is Murugesh Charati?
He is held up in another court. He is arguing in another court, my lord. My lord. 15 point, the steps to be taken by the 15.1 and 15.2, my lord.
15.1, there is
15.1 is
steps to
ours.
be taken?
715 of 22 is Murugesh Charati appearing for. I am appearing for 715 of 22, my lord.
Yes, 715 of 22.
A report had to be filed, my lord. The direction was given on 30th.
Non-filing of production material.
I'm not ready.
To
my
show
lord.
that
Kindly
our
have
land was
another-
utilized.
Another day.
Huh?
I'm not ready, my lord. Kindly have it another day.
You know,
I'm not ready today, my lord. Kindly have
There is an
it.
order directing you to file a report
file the report.
in 15.1. Have you filed it?
Sachin has taken steps to be taken, my lord.
BPM 6 stage found lapse.
I think we heard for
Hmm.
some time.
I think we have also passed orders.
May I request for the matter to be taken up separately, my lords?
Just a moment, please. 5, 6, 20.
All the matters are BTM 6 stage only, my lord.
Yes, see, first awaiting service note, the next to the non-filing of, what is the non-filing of acknowledgement? 15 only, 756.
Not
Have you
those.
served the copy? You are not appearing in 756.
No, my lord. Sachin appearing. DS Sachin appearing.
IA3, IA3 ಅಲ್ಲಿ 756 ಅಲ್ಲಿ IA3 of 29 ಅಲ್ಲಿ the production of translated copy of annexures kept in abeyance ಅಂತ for the time being. Next IA1 of 25 ಕೂಡ ಸೇಮ್ ಹಾಕೊಳ್ಳಿ, kept in abeyance for the time being ಹಾಕೊಳ್ಳಿ. 1 of 25. IA1 of filing Supreme Court order. Stay. A week's time granted ಅಂತ ಹಾಕಿ for to do the needful. Rest of the office objections are concerned. 756 ಅಲ್ಲಿ 15.1 ಅಲ್ಲಿ 715 ಅಲ್ಲಿ a week's time granted. 15.1 a week's time granted.
If there's a direction to file a report, please file it within that time.
To file the report ಅಂತ
The
ಹಾಕೊಳ್ಳಿ.
second part, we have received copies. That may be. The second point, my lords, non-service of copies, we have received copies, my lords.
You've received.
Yes, 15.1 ಅಲ್ಲಿ ಹಾಕೊಳ್ಳಿ. Land counsel for the respondents have been said they received the copies of the copies of appeal. Appeal. Yes.
Appeal and all connected.
Yes. However, a week's time granted to produce the report, to place the report by the land counsel for the appellant. 15.2 only, what is this? Rectification of his objection. A week's-
1020 days delay.
A week's time granted to rectify the office objections process. Yes. Next, delay. Delay of 140.
Delays in which?
16. Yes.
16, 715, I have the copies, my lord.
21 days delay.
It is survival. It's attached.
Oh, not.
Fine.
16. 16 is the 1020 days.
Respondent, alerts appear for the appellant. Around 150 batch matters, out of which only 15 remain. All other matters were allowed and remanded by. Alerts that recently disposed of 7 out of this batch matters. The judgment of this is here.
These also have to be remanded.
Yes, my lord.
In these two cases, my lordship, already the award amount is satisfied, my lordship. I placed the execution proceedings
What is
before your
there to
lordship.
be remanded?
I placed the execution proceedings before your lordship. If lordship has granted 1 week or 2 weeks time.
Alerts, out of 16 matters, I was to serve the parties.
Maybe true, counsel, but in the meanwhile, they're saying that the award stands satisfied. Then what is there to
Please
remand?
withdraw the entire amount.
So please
For-
place it on record.
Yes, my lordship.
Which
Yes,
matter?
learned counsel
In these
to
two
respond.
matters, 16, 5259 and 708/21.
I appear for in 16, 2, 9 and 11.
In two matters, the award amount is satisfied, my lordship. 5259 and 7088.
5259, 5259 and
7088.
7088, 16.5 and 16.8.
I appear for 16, serial number 2.
There also award has been satisfied.
No.
So only 16.5 and 16.8.
I know information.
Please wait just
with
a
regard
moment. The learned counsel appearing for the respondent submits that the award has already been satisfied in execution. The learned counsel seeks a short accommodation to place material on record. List after 2 weeks.
Yes, my lordship.
Yes, 16.2.
I have serial number 2, 9 and 11.
Yes. 2, 9,
9 and 11.
9,
11
and
11.
Hmm.
2, 9 and 11.
Ah,
In 3 cases.
yes.
I will ascertain whether the amount has been already satisfied or not.
If it is not satisfied, then we'll consider.
Yes, ma'am.
Yes. Learned counsel for the respondent seeks a short accommodation to verify whether the award has been satisfied. That is 16.2911. Rest of the matters also we listed after- list after 2 weeks. All the matters we can list after 2 weeks. If the award has not been satisfied, then we'll consider remanding it.
Let them file memos.
Yes. After 2 weeks, give a date before holidays.
Memo file ಮಾಡಿ.
Yes. 29.
By that time, I will file the memo.
Seventeen. Cheetal Soni.
I appear for the respondent competent authority.
Notice to R2. Who's R2?
R2 is the financial
Financial
establishment.
establishment. May not be necessary. Who appears for the appellant? Is notice to the financial establishment required?
Cheetal Soni.
No appearance.
I
They've
monitored
not
while
taken
I
out
am
notice at all. There's a direction to take out notice.
Yes.
Not taken.
Yes.
Do they have an interim order?
No, my lords.
Anyhow, take out notice, whatever the complaints, notice, so let them take the process.
Please, please.
Yes, yes. Take appropriate process. A week's time granted. A week's time granted to take appropriate process. Steps.
18 disposed of. 19. Gangadharappa Evi.
The first respondent is the claimant number 1 before the reference court. Lord, he has died in the year 2010. No steps have been taken by the other claimants to cause the LRs on record. Lord, I came to know of the death, my Lord, only when the notice was issued by this honorable court. Lord, accordingly, I filed IA number 1 of 24 to implement the LRs as additional respondents. I have produced the copy of the death certificate along with the
Notice issue.
notice may be out.
Yes, yes. Issue
But insofar as the office objection regarding non-taking steps in respect of R1 minute, that may be overruled. Since I have filed the application for impeding.
You're for the respondent, huh?
But I am for the appellant.
Sorry. The learned counsel for the appellant filed since the learned counsel for the appellant filed IA 1 of 2024 to implement the
LRs of this is R1.
R1, the office objection in respect of non-taking steps is to non-taking steps in respect of R1 is overruled. Issue notice on IA 1 of 24.
Two contempt of court cases for special order.
Special order.
Not I appear in this case.
These contempt of court cases are listed by special
Where,
order.
my lord, your lordships had directed them to file their reply.
But I'm filing a memo, my lord, these two memos, I'll show you a couple of. Where, my lord, the matter, my lord, is pending before the Supreme Court, my lord, stayed also, the interim orders passed. Connected matter, my lord, is being dropped.
My lord, may I make this submission, my lord? The government advocate, my lord, should be fair to the court. My lord, in fact, if your lordship sees the order passed by your lordships on 19/4, my lord, what happened was the writ appeals filed by us, my lord, were allowed. There was a final order saying that our possession should not be disturbed. In spite of that, my lord, when we go there, my lord, they disturb the possession. They say that we are not bothered about the High Court order and only what the commissioner says. In fact, the car where the advocate was there, my lord, they stop it at Makey Circle and they try to, my lord, tag. And now what, my lord, the Supreme Court order, what is saying, last time I produced, if your lordship sees, the government files an SLP before the Honorable Supreme Court. And I would rather say very strangely, in the SLP filed by the government, the Supreme Court protects my possession again. So, my lord, if that is the case, this is a contempt which has already taken place for which they have to file their, in fact, your lordships had very clearly said they have to file a reply to this. Lord, this cannot be a ruse for them that in the Supreme Court the matter is being heard. But this is a contempt that has been already committed.
Till the next stage of hearing, possession of the disputed property.
That is in their SLP, my lord, even the Supreme, what your lordships, my lord, if your lordship sees the order passed by your lordships on 19-4, in the contempt, my lord, after your lordships were convinced about this matter, your lordships protected our possession because of the high-handedness, my lord, where the protectors of the society turned predators. Your lordship protected our, in fact, the Supreme Court against that order, my lord, we have produced the copies where if your lordship sees, so again our possession is protected. So, my lord, this is, and even otherwise, Lord, what they have done that day, Lord, that is a contempt that has been committed. So, for that, they were supposed to have replied. Till today, my lord, they are not replying to this.
Even in the further order that you've produced,
My lord.
it says that interim order passed earlier. shall
Yes, my lord,
constitute
that is in our favor.
Yes, my lord. The very same order, my lord, was placed before my lord. My lord, kindly come to page number 4.
No, therefore the question would be this.
Yes.
Was there a contempt of the order passed by this court?
No, my lord.
Now,
Because
for
it
you
was-
to say no, where is your affidavit?
My lord,
Where
here,
is
my
your
lord,
objection?
see,
Where is your
here,
affidavit?
my lord, we are still in possession of the property from that point of time, because parade is going on, flag hoisting is going on, and our
question.
control room is there in that premises.
That again is not the question. Please,
Yes, ma'am.
please file. File. Which was the judgment?
My lord, your lordship's order on 19-4. There, their interest was protected. Your lordships protected their interest that we will not, my lord, interfere with where they have, and we didn't want to, and we ourselves made a submission before your lordship. Your lordships have recorded that.
Serious allegation raised in the reply is required to be filed by the respondents.
Yes.
At view of the matter, respondent shall place on record the reply within 3 weeks. In the light of the directions issued by the division bench, respondent shall not interfere with the appellant's possession of the land. Learned senior counsel appearing for the petitioner, there shall be no attempt at this present point of time to disturb the sheds which are existing in the property which have been put up by the respondents. List this immediately after Summergation 2024. This will not preclude the respondents from hearing the review petition and seeking a posting of these contempt of court cases along with the same. So what happened to your review petition?
Review petition, they were, my lord, they in fact withdrew it, they were dismissed because they filed there also in that contempt before the Honorable Division Bench. My lord, they took up a contention of that review is pending. My lord, the Honorable Division Bench was not, my lord, keen on looking into it because review itself is not like any appeal that has been filed. It's very limited thing. Then, my lord, they went to the Honorable Supreme Court in that particular matter. But here, my lord, when the Honorable Supreme Court itself has protected our position in their SLP, my lord, they have to file the reply, and my lord, otherwise charges will have to be framed against them. The high-handedness of them, my lord, they don't even file a reply till date.
Writ Appeal 5614-154 of 2017 is allowed. Government order dated 11/10/2017 is squashed. Respondents are restrained from interfering with the appellant's possession and enjoyment of the land in
Yes,
question. Writ Appeal is allowed, order dated so and so. Now it is your contention that that order is wrong. But that order,
Pardon me.
it is your contention that the order was unfounded,
Yes,
wrong,
yes,
etc., etc.
Yes, ma'am.
So what about the order of the apex court in your SLP, which says that their
Our
possession shall
possession,
not
they
be
protect
disturbed?
our possession.
My lord, that we have, my lord, I produced that copy, that there is an order to this effect. I mean, it remained protected, my lord. My lord, may kindly come to page number 3 of the memo, my lord. The orders of this Honorable High Court, my lord, the first court. Paragraph number 2. Paragraph number 2 says, it could be noticed that the Honorable Supreme Court has passed an interim order directing not to disturb the possession of the disputed property. Not to disturb the possession of the disputed property. Even prior, I was in possession
Lord,
and
may I
still
just
I am in
make this,
possession.
my lord, I'll clear this, my lord.
And my lord, next
This, my
page.
lord, what
Lord,
they're trying
kindly
to
come to the
tell
next
is,
page.
there was
Kindly, my
one
lord,
more contempt filed because in the order passed by the Honorable Division Bench, there was a direction to enter our name in the mutation. So, my lord, that was not done, which we filed a contempt. There, my lord, the Honorable Division Bench said that mutation entry, anyway, your possession is protected. So there it is that particular contempt that you have not done something which you are supposed to do. But here in this case, what they have already done, it has already been done. So, my lord, they cannot escape by saying that, even assuming for a moment, my lord, the Honorable Supreme Court, my lord, assuming for a moment, Honorable Supreme Court, my lord, allows their SLP, but still that contempt that has been committed stays.
If it is a contempt, it stays, which is why we had required you to file an affidavit.
We will file now.
That has to be filed.
I will.
That
make
has
the
to be
necessary-
filed because unless the question whether there has been a contempt or not is decided,
Yes.
there's no question of closing it.
Yes, definitely. My lord, here, my lord, one aspect. Based on this, my lord, it is submitted that the present contempt petition does not survive for the present.
What is the
That was-
present contempt petition?
As far
there?
as
That is
that
for
case is
mutation
concerned,
entry.
they were all connected matters. my lord.
That is not the case.
Separate
And
directions.
Here, what has happened is,
Complaining, they are complaining
I am
of an
only a
overt act.
beneficiary.
No, they are complaining of an overt act of contempt.
I will file my reply.
Such a complaint is there, then they are no longer relevant. It becomes between the court and the contemner.
Yes.
Therefore, the question that we have to consider is whether there is a contempt committed
I'll
by
file.
you or not. Now it
I
is
will
for you
file.
to say so.
Yes.
The role of the petitioner is limited to bringing this fact to our
Yes,
notice.
that's all.
Now, as it has been brought to our notice, there has been a direction for you to file a reply
Yes, I'll
or
file
an
my
objection.
reply.
It has to be filed and we have to independently consider whether, now the role of the petitioner is over. It is now between the court and the contempt.
Yes, please. I will
There
do
is a
it. I'll do it.
contempt or not, whether there is contumacious conduct, whether it was deliberate, all those are
Yes,
just
madam.
questions between the
Yes,
court
yes,
and the
yes.
contempt.
Very-
Yes,
Yes.
please place it
I'll
on.
file my reply. my lord.
Lord,
Yes.
at least otherwise, my lord, if they don't file the reply, then it should go for framing of charges. Otherwise, they will not file, my lord. It has been such a long time. Unless
be a
there is some
consequence,
deterrent
madam.
by this court, my lord, they may not file their reply
Because
again.
this
I will
court has
file.
directed, it has to be on
I will
record.
file it.
Yes, learned Additional Advocate General seeks a short accommodation to place the
The reply.
reply on record. List on. Give a date. 10 days?
Please,
Time after
29th.
no,
29th, let them, my lord,
second,
why,
I'm
my
out
lord,
of
let them
station.
file the reply. On that date, your lordship may
27th,
then again
one
give
day
them time.
before. 20.
20.
29th, my lord. May I request for 29th.
I am not in town. Why?
Please, let it come on 28th.
One day earlier, I am seeking.
Yes.
Obliged.
Obliged.
21, Murugesh Maturity.
Is this?
I'm appellant in 21.2.
21. What is this?
This is that matter, my lord, where, Lord, I appear for the appellant in one of the matters where I appeared for the Indian Express, and my learned friend, my lord, represented by the senior counsel Soudewala for the High Court, where, my lord, the learned single judge, my lord, had imposed a cost of 10 lakhs on us, though, my lord, that was not their prayer, and their prayer was to remove that thing from that. And your lordships had granted an interim order on the last occasion. This matter was supposed to be heard.
Can we hear this immediately
Yes, ma'am.
after? We remember the
I'm
matter.
appellant in 21.2, my lord. I have filed an application to permit me to conduct the case in person.
Please.
That can be allowed
Yes, yes, please.
without anything further?
Yes, ma'am.
Yes.
There are
the
some more
application.
applications, my lord, where I have sought for some dispensation. IA number 1 is
All that can be allowed?
Yes, that can be allowed. Now, 21, what is this? Furnishing of so and so.
IA number 1, my lord, I am seeking permission to.
21.
Yes, my lord.
PF to R1.
Yes.
A week's time granted ಅಂತ to do the needful. 21 ನಲ್ಲಿ ಆಫೀಸ್ objection do the needful ಅಂತ ಹಾಕೊಳ್ಳಿ. 20.1 ನಲ್ಲಿ 21.2.
Yes, my lord. IA number 1 is seeking permission to
accepting the reason
in person,
assigned.
my lord.
Accepting reason
Yes.
assigned, IA 1 of 24 is allowed.
IA
The
number
council,
IA
so
number
and so, so and
IA
so is
number 2, my lord.
Permitted to prosecute this petition, this appeal. Yes.
IA
What is
number-
this IA 4?
Permit me to serve copies on the advocates who are representing the respondents before the
Maybe
learned.
Yes, IA 4 also allowed ಅಂತ ಹಾಕೊಳ್ಳಿ. Accepting the caution, IA 4 ಮತ್ತು 3. of 24.
And IA number 3, my lord, dispensation of service
Yes.
to R12, who served but did not appear before the, during the writ petition. IA number
Yes, since the respond number 12 is those served not represented before the writ court, the IA 3 of 24 is allowed. The notice to R12 is dispensed.
Yes. And IA number 4, my lord, I have produced about 6 volumes of documents.
So
I am seeking dispensation of.
Yes, accepting the cost on the vide alva. IA 4 of 24, it's dispensed. The production of
Yes.
production of documents. What else?
Is that opposed?
6 volumes of.
Is that opposed? No, he is seeking dispensation. Is, may not be. Okay.
Yes, it's allowed.
Then, my lord, I have, there is 1 day delay in filing the
7
appeal. I
days.
have filed application.
7 days. 7 days. Five.
Other accepting caution on Takoli, delay of so days for condoned. IA 5 of 24 is allowed. Next, IA, what is it? IA 2 of 24, direction.
That may be.
Yes.
Seeking permission to serve copy.
Shall be called along with this main appeal.
Grateful.
Re-notify after, in the first week.
First week.
First week. Re-notify the first week.
4/6.
Non-compliance office objection, payment of court fee, office objection is overruled and.
Yes, intermodal shall remain.
Office objection in other 3 matters, my lord. The first matter is already.
This is the order passed. Regarding the court fees, since only interest claim is made. Second. Second.
Office objection. Payment of court to be paid is appeal resisted. No, that is the only office objection.
That is the only.
Any other idea, madam? No, where is another idea?
So in first matter, respondent 2 and respondent 3 details to be stated as per the trial court. In second
Details to be
matter,
stated.
Necessary court fee for that. No.
Yes.
Second
That
set
is
to be
mentioned.
filed.
Yes. A week's time to comply the office objection. Yaudadu, madam, what is it?
Respondent number 2 and 3 details to be.
To furnish the details of respondent number 2 and 3. A week's time. In 22 only. No order is required for this one. It's already payment.
It's already there.
It's already there. Not required, yes.
For 22, it is not. This is the-
Court fee.
Yes. What about 22.1?
Second set, they are not filed.
Other a week's time granted. Fourth time.
Filed the counter, my lord. If it's not-
Finally, a week's time granted to comply, to do the needful. 22.2.
Same. There are 4 matters together.
Yes. The 22 and 2 in the 3,
22.1.
4. 2 mattu.
I'll verify in all the matters.
22.3, the same
Court fee.
order. Same order.
For court fee, the same order.
Same order.
And anything else, a week's time.
22.2 ಮತ್ತು 22.3 ಅಲ್ಲಿ court fee same order. Earlier order ಇದೆ same order. Yes. ಇದನ್ನು ನೋಡ್ಕೊಳ್ಳಿ.
This is the order. For the credit of the society.
23, Giresh Arbudia.
2 days time may be granted. Pay the court fees and verify the.
Let request let request of control support the appellant. A week's time granted to comply. Before non-compliance
24,
of his objection.
Leela Krishna, court fee.
Paid court fee on Saturday. Same may be verified.
It is submitted by the learned counsel for the appellant that he has complied the office objection by paying the necessary court fee. If that be so, office to verify and put up.
passed all matters.